Good morning and welcome. Thank you for joining us today for a discussion of common misconceptions about GDPR compliance for US-based companies and organizations. My name's Alex Schneider. I'm an associate attorney at Marashlian Donahue, the CommLaw group, specializing in regulatory law analysis and compliance in the areas of telecommunications and privacy law. I hold the International Association of Privacy Professionals Certified Information Privacy Professional, United States certification. I'm joined today by Eric DeHert, the CommLaw Group's outside legal consultant with more than 10 years of experience in the area of European information, communication, and technology law, including data protection law and cybersecurity. Eric is on the line from Belgium. Also presenting today will be Linda McReynolds, of counsel to Marashlian Donahue, practicing primarily in the areas of telecommunications and privacy law. Ms. McReynolds holds the International Association of Privacy Professionals Certified Information Privacy Professional United States certification. She counsels clients on issues arising under federal, state, and international laws addressing privacy and data security. Many of you in attendance today have shared some questions during the registration for the webinar. We'll be addressing many of these questions throughout the session, but we will be leaving 15 minutes at the end for additional questions. So let's get started. Okay. So again, it's my job this morning to introduce GDPR, the General Data Protection Regulation, in a nutshell. That's no easy task, but here are some key components to GDPR that are important to understand. GDPR became effective on May 25th, 2018. It's a regulatory framework implemented in the European Union, the EU, that governs the processing of personal data of EU data subjects. By processing, we are talking about operations performed on personal data, whether or not by automated means, such as collection, recording, storage, use, disclosure, dissemination, or destruction. By EU data subjects, we're talking about an identified or identifiable natural person located in the EU. The GDPR embodies the principle that data protection is a fundamental right for EU data subjects. By personal data, we're talking about any information relating to a EU data subject. The GDPR imposes direct obligations on both data controllers and data processors of personal data. A data controller is the entity that makes decisions about processing activities, regardless of whether it actually carries out any processing operations. The processor, on the other hand, is any person or entity that actually carries out the processing on behalf of the controller. Now, one of the reasons we're here today is that the GDPR imposes significant penalties for non-compliance. Under the GDPR rules, the fines for non-compliance are up to the greater of 20 million euros or 4% of an entity's worldwide annual turnover. This risk, and even the risk of bearing the burden of going through an investigation for potential GDPR violations, has caused US companies to take notice. Now, on this slide, we're going to talk a little bit about what's happened in the last month or so. GDPR was implemented at the end of May, and since then, we've seen various different reactions. Max Schrems, a privacy consumer activist, already filed complaints against Facebook and Google, alleging violations of the GDPR. The Information Commissioner's Office, ICO, in the United Kingdom, received more than 1,000 data protection complaints. There have been a flurry of individual requests for information about companies' use of personal data, and this may be partially related to the timing of the Cambridge Analytica scandal involving Facebook data, which has recently raised the profile of data protection issues among consumers. So all of these developments have led to some confusion, some uncertainty with regard to GDPR. Now, on this side of the Atlantic, we're seeing reactions to GDPR that are not always ideal. Some US media organizations and companies actually close their websites to EU visitors to avoid GDPR liability. Many similarly situated companies in the US are trying to figure out how they should react now that GDPR is being enforced in the EU. So with that, we're going to turn to the main topic of today's presentation, which is common misconceptions.
Thank you, Alex, for that overview. I think that so many of our clients have contacted us looking for a checklist or some sort of one and done, one size fits all solution, just trying to wrap their arms around whether GDPR applies. And then once they determine that it does, what are the steps that they can do so they can be compliant once and for all. And part of the purpose of our presentation today is to encourage companies to neither be so overwhelmed because they feel like the GDPR is so complex that they'd rather just shut off and lose business opportunities in the EU rather than try to grapple with the complexity of the framework. Or on the other hand, looking for something that they can just do across the board to be covered in every way. So today we want to go through just a few kind of frequently asked questions and misconceptions that we have encountered among our clients. I'll turn it to you, Eric.
Yes, thank you, Linda. Yeah, I'm trying to get over my hangover today because yesterday we lost with our soccer team, the Belgian soccer team, in the World Cup of Soccer against against France. So I hope to quickly also get over it. But starting with the first misconception, that is that some people think that the GDPR is a completely new law. Actually, the GDPR marks a big shake-up to the European data protection laws, but the core principles in the GDPR are very similar to what was already existing in the data protection directive. Now, I don't know if you're familiar with the difference between a directive and a regulation. The GDPR is a regulation, which means that it is implementing in all the EU member states without having, having this lack of harmonization, which might be due to for instance, a local implementation of directives. Now, in particular, the GDPR retains most of the core concepts of the data protection directive, such as personal data controller and processor. It also preserves the core requirements that personal data should be processed in a fair and lawful way for limited purposes. The usage should be minimized, and the personal data should be accurate, secure, and not to be kept longer than necessary. However, there are a number of big changes. These includes, for instance, some tweaks to those core concepts, such as a more restrictive approach to consent. We will elaborate later on in one of the next misconceptions, as well as a broad extraterritorial reach, meaning that the GDPR will also apply to many US businesses. Secondly, there are a number of new compliance obligations and accountability obligations, such as, for instance, the need in certain cases to appoint a data protection officer to carry out data protection impact assessments and to update your contracts even as a data processor. There are a number of new obligations as well. Obligations for data processors and data controllers, and on the other hand, associated with that, new rights for data subjects, rights for individuals to, for instance, have access to their personal data, the right for portability, the right to be forgotten, etc. One of the duties for the data controllers, for instance, is the duty to notify in case of a data breach. And then last but not least, there are higher penalties as well. That is something where we will come back to that later on if needed. So in other words, if you were largely compliant with the old data protection directive, the additional steps to comply with the GDPR now should not be too painful. But yeah, what happens is that the GDPR marks an evolution, not a revolution in data protection laws. Then we go to the next one, the next misconception.
Okay, thanks, Eric. The next misconception is that the law protects EU citizens wherever they go. It is true that there is, as Eric said, an extraterritorial application of GDPR, and that means that the GDPR applies outside the EU in some cases. More specifically, US businesses will need to comply if they meet one or more of the following criteria: if they establish a presence in the EU, if they offer goods or services in the EU, or, and this is important, if they monitor behavior of individuals in the EU. When we speak about individuals in that case, the question is whether the individuals are in the EU, not whether they are EU citizens. So citizenship is not a prerequisite. Now, if you meet one of the criteria, you only need to comply with the GDPR with respect to personal data of EU data subjects, not personal data for other data subjects.
This is the next misconception relates to consent. And just as a person looking at the internet, I'm sure many of you have seen lots of banners, lots of click-throughs and tags requesting consent to different privacy policies, data processing, or transfer lately. And so one thing that's important to understand is that consent is only one of several lawful bases for processing data. It is also a lawful basis for transferring data. I'm just going to limit this to looking at processing data in the first place. But the 6 lawful bases are, no one is better than the other necessarily. And so it's important to evaluate whether you have a different reason for processing data that you could rely on other than consent. And just to run through what these are, you can process data if it's necessary for the performance of a contract or to enter into a contract. If you are subject to a legal obligation under EU or member state law and it's necessary, you can do that. Processing that's necessary to protect vital interests of the data subject or another natural person. Or if it's necessary, if processing is necessary to perform a task that's in the public interest or it's in an official authority that a data controller has. Another reason is if it's necessary for purposes of legitimate interests that are pursued by a controller or third party. And I won't get into all of the nuances, but that's a balance between the fundamental rights of the data subject and the legitimate interest of the controller. Consent is another legal basis, but keep in mind a little warning about the use of consent, if I will, that if you seek consent in order to process data in the beginning and you tell the data subject that that is the legal basis, and later that data subject withdraws consent, you can't then say, oh, actually we have a second reason to process this data, it's to perform the contract. You can't go back and change. So if an end user, if a customer withdraws consent, you have to honor that request. Another wrinkle about consent is, as with all of these lawful bases, the processing must be necessary for a particular purpose. And when you get a data subject's consent to process data, you have to let them know what the purpose is. If that purpose changes, you need to get consent again. Whereas if the purpose changes and you're using a different lawful basis under some circumstances, you can continue to process that data for a different legitimate purpose. Another point about consent is there are several conditions about consent, and one of them is that it must be freely given. So if there's an imbalance of power, and one example is an employment relationship where an employer is seeking consent from an employee or a candidate for hire to process data, that may be viewed as an imbalance of power where someone thinks if I don't consent, maybe I won't get the job or can't keep the job. And in that case, the consent will not be valid. So that's why we say anything but consent. It doesn't mean that consent is not valid, but don't go to consent first. Consider whether there's another reason.
Okay, then we go to the next misconception, that is that any breach will result in huge fines. Because if you read most of the articles on the GDPR, they all start or end with a warning that breach will result in huge fines. It is a fact, of course, that the GDPR raises the risk of very significant administrative fines. Breaches of most provisions of the GDPR can result in a fine up to or greater of 4% of the annual worldwide turnover, or 20 million. In some cases, this is a big number. For example, the privacy activist Max Schrems recently made complaints, as Alex explained, against Facebook and Google, pointing out that they can be fined up to 1.3 billion and 3.7 billion respectively. And for some of these big US techno companies, these figures are not entirely theoretical. However, most organizations are very unlikely to face this level of sanction. For example, we know that, for instance, in the UK, the Information Commissioner has never issued a maximum fine available under the old law. So the odds will be against the Commissioner indeed now finding or starting to fine new companies with those huge fines immediately. And even then, only the fines would only be applicable for the most serious breaches, so not for all the breaches. So there is some kind of tiered system to impose those penalties. When deciding whether to impose a breach, a supervisory authority, such as, for instance, the UK Information Commissioner, must take into account a number of matters, like, for instance, the nature, the gravity, and the duration of the infringement, whether the infringement was intentional or negligent, whether actions to mitigate have been taken by the data controller or data processor, whether there were measures taken to prevent the infringement, what about the previous track records, etc. So yeah, supervisory authorities also have a number of new and revised powers under the GDPR, which includes the ability to carry out audits, to order remediation, or to erase or to order erasure of data, and even also to suspend data transfers. Data subjects will now also have, and for the first time, a course of action against data processors to seek compensation. And what is quite new too, that is that group actions are encouraged as well, rather than individual actions. So the risks associated with non-compliance have increased for sure, but there is in general no need to panic. We can go to the next one.
Yep. The next misconception is that the GDPR only applies to big companies that collect a lot of data from EU residents, or even that meet specific financial thresholds. And this is one misconception that we received some questions about before the during the registration for this webinar. In fact, the GDPR applies to organizations of all sizes. All businesses that meet the GDPR criteria must comply, regardless of revenue or number of employees or any other potential exemptions from other kinds of laws that are not specific to the GDPR. Organizations affected by the GDPR include, but are not limited to, organizations providing online services or sale of products, communication and internet service providers, IT and software or anything as a service providers, social media platforms and search engines, and websites using information tracking features such as cookies, even when those features are automated. However, since the question was asked, we should say that in some circumstances in GDPR, there are times when there are exemptions for certain smaller companies. One example is the appointment of a data protection officer is not always required, and there's specific language in GDPR about that.
Another question that has come up is whether the GDPR requires encryption. And generally speaking, the answer is no, although the GDPR mentions encryption throughout, including in the recitals that are quoted here and also in Article 32 regarding safeguards. The GDPR provides a scalable risk-based approach, requiring that you take into account a number of factors and look at the context, the purposes of processing, look at the risk, the likelihood, the severity of a breach or different risks on the freedoms of natural persons. So the GDPR requires that a controller and a processor implement appropriate technical and organizational measures to ensure a level of security that is appropriate to the risk, and one of those may be encryption. Keep in mind that encryption alone may not be sufficient. So again, this is but one means that can be a very important technical safeguard, but there should be other organizational safeguards as well. So data security, as we mentioned here, features prominently in the GDPR. So even though encryption is not required, an appropriate level of security to protect against risk is required.
Okay, one of the next misconceptions that is that we only need to look at the GDPR in terms of compliance. Well, the GDPR provides a detailed set of privacy rules, but despite its length and complexity, it does not provide a complete overview of all your obligations, whether you like it or not. So you also need to factor in a number of complementary laws, such as the e-privacy directive. There is an e-privacy directive applicable today, which is being discussed now before the European Parliament to be replaced by a new e-privacy regulation. This regulation aims at reinforcing trust and security in the digital single market. Amongst other things, this requires you, for instance, to obtain consent for the use of certain cookies, and only permits the sending of direct marketing mails if you either have the individual consent or similar products or services exemption applies. Like, for instance, in some member states, there is an exemption for sending emails to corporate subscribers. The e-privacy legislation is now being adapted to align with the GDPR. So normally we expect that most of the provisions will be aligned, but the final draft has not been discussed or certainly not been decided yet. So this is still to be seen. A second one where we would like to draw your attention to, that is the Network and Information Systems Directive, the NIS Directive, which has or needs to be implemented by local European law in May 2018 now. And this is one providing legal measures to strengthen the level of cybersecurity in the EU to operators of essential services such as banking, energy, healthcare, and digital infrastructure. This directive contains a number of overlapping provisions on security and incident notifications. We haven't discussed that in detail, but there is an obligation, for instance, under the GDPR for data processors and data controllers to notify the authorities and sometimes also the data subjects as soon as there is a data breach. And a data breach is considered as being quite open. That means any kind of loss of data or breach of any kind of data subjects. So the provisions of the NIS directive also affect digital service providers, DSPs. That means certain cloud service providers, online marketplaces, and search engines. The inclusion of digital service providers within the NIS scope now places an additional potential breach obligation on these service providers. Again, those provisions will be aligned as much as possible with the GDPR, but there are a number of overlapping provisions. In addition, the GDPR may be supplemented by each EU member state's implementing laws. The GDPR allows for certain competence for the national jurisdictions to implement a number of additional provisions which come on top of the provisions which are already stated in GDPR. But most of the member states today have not passed yet these national implementation laws.
Okay, thanks, Eric. The next misconception is that US companies cannot import personal data from the EU. Now, the reality here is nuanced. As an initial matter, GDPR did not make material changes to the rules on cross-border transfers of personal data. That said, GDPR has raised the stakes, given its enforcement penalties, incentivizing companies to carefully plan and execute how they transfer personal data across borders. Now, in some cases, there are EU adequacy decisions that permit transfers. There's decisions for countries like Argentina, Israel, New Zealand. Many of these decisions were made prior to GDPR and remain. Transfers to the US are still not covered by an adequacy decision. The EU-US Privacy Shield replaced Safe Harbor after the torpedoing of the EU-US Safe Harbor regime by the EU's highest court. But Privacy Shield itself has faced criticisms and legal challenges and could even be invalidated. We're monitoring the status of Privacy Shield, but it's important to understand that the law on Privacy Shield is not yet set in stone. Transfers are also permitted in GDPR where appropriate safeguards are implemented. So this is beyond just a country umbrella. This is more specific to appropriate safeguards. The list of appropriate safeguards include binding corporate rules, which now have their own section in GDPR, Article 47, and standard contractual clauses. In Article 46, GDPR also introduces approved codes of conduct and approved certification mechanisms. Article 49 of GDPR, meanwhile, includes a list of derogations permitting transfers in specific situations, including where consent was obtained or in performance of a contract. So there's a few takeaways from all of this. First off, GDPR incentivizes diligence with regard to data flows out of the EU. Second, any transfer policies currently in place should be reviewed to assess compliance with GDPR. And third, when transferring data within an organization, binding corporate rules provide a good basis for transfers, demonstrate compliance with GDPR, and are less likely to be impacted by any future determinations about the viability of the Privacy Shield. So there is an ability to move personal data around, but within these frameworks. Now we're now coming toward the end, and before I go to the next slide, I wanted to let everyone know that On your screen, there's a toolbar where you can ask questions. We are taking questions for the final part of our webinar, so please use that. And I'm going to turn it over to Linda now.
Thank you, Alex. So I think to sum up, while we've addressed some misconceptions, some of the questions we've been seeing from clients, the overall message that we want to convey is that you should neither panic and run from GDPR compliance by shutting off the EU as potential business opportunities there, nor should you rely on a sort of one and done checklist of one size fits all solution. So as Eric mentioned at the beginning, if you were compliant with the Data Protection Directive, and I would add for many companies, you already have in place safeguards of data. And so you like taking the test where you are and do some analysis, determine whether the GDPR applies to you, map the data that you process, get your arms around who are your customers, who are the third-party vendors, and really take an inventory of where the data flows and what are the uses, what are the purposes for which you use personal data, and where is it stored. So once you've done this sort of data mapping, I find that you are much farther down the road toward compliance than you initially might think. And so develop a plan from there and understand that the GDPR framework requires ongoing compliance. There are ongoing responsibilities, so it's not something that you can sort of give yourself a certificate or a stamp of approval and be done with it, but instead implement processes that you can maintain and refine over time.
Thanks, Linda. So we are taking questions. Again, you can use the toolbar on the right-hand side of your screen to submit a question.
Maybe, yeah, one of the questions that we received, that is that what are the initial areas of enforcement where, for instance, authorities might start with enforcing to make sure that companies, data processors and data controls are compliant with the provisions of GDPR. Now, our vision there is that basically authorities seem to tend to envisage or to focus first on the big companies, certainly not the small or the medium-sized companies. Big US companies will certainly also be under scrutiny to make sure that they are compliant with all the provisions under the GDPR. As we explained already, the GDPR imposes onerous accountability obligations on data controllers. This includes, for instance, the obligation to maintain records of all processing activities, to conduct data protection and impact assessments in certain cases, to implement data protection by design and by default, and lastly, to notify certain data breaches. So it will be quite important to see how companies will react on when data breaches are being detected, because the notice or the delay within which you need to react is very short. You only have 72 hours within which you need to notify the authorities, and in some cases also the data subjects, about a breach. And again, a data breach is really quite broad. That can be any kind of loss of data or any kind of unauthorized access to data. Like for instance, if a laptop would have been stolen out of a trunk of a car of one of your colleagues or employees, that could already be considered as a data breach. Data breach obligations exist already under the previous system, so this is something where we see that authorities will certainly also continue to conduct their enforcement actions.
I see another question that has come in is because a lot of our client base deals with this kind of information, is whether call detail record CDRs are within the scope of GDPR. This raises a related kind of misconception about pseudonymizing data. So the GDPR covers personal data, which means information that is related to, it identifies, or a natural person would be identifiable with this data. Sometimes you can, as one safeguard, separate out the information that would make that data linkable to a natural person and make it pseudonymous. But it is still, that is a safeguard to protect personal data, but it doesn't take it outside of the definition of personal data. So it's important to understand the difference there, that is just a safeguard or a mechanism that you can use as a way to protect personal data. So if CDRs contain information that is linkable to a natural person, and again, just a reminder, this is linkable, it's EU data. So, you know, if your CDRs contain information about EU residents linkable to them, then it would be covered by the GDPR.
Okay. Another question that also was raised by the audience was if it was really needed to change the terms of service or the privacy policies. Now, the answer clearly is yes. Data controllers must be more transparent with data subjects about their processing activities. Individual data subjects must have information made available to them about the manner in which and the purposes for which their personal data are being processed. And this must be done in a very concise, transparent, intelligible, and easy or readable way. In practice, that means that that you need to review your privacy policies to ensure that all required information is included. The review privacy notices should be readable. That means that you need to consider using plain English and not legalese. You should also consider high privacy notices are being communicated to your users or to your customers. Consider whether, for instance, to give your privacy notice just in time, and consider, of course, too, a process that the privacy notice might be adapted in the future, and to record all the new versions of the privacy notices. As far as terms of service are concerned, these will also need to be adjusted and accommodated to the new provisions of the GDPR. One of the obligations is to ensure that data processors and data controllers enter into a specific agreement on the processing of personal data from, for instance, customers. You can include that in the existing contract, but typically this would be some kind of annex or schedule to your existing contract that is specifically dealing with how you deal with, for instance, instruction from the data controller to the data processor about processing of personal data.
A question just came in about request the right to erasure. The GDPR contains a number of individual rights for data subjects, including rights of access to information, the right to correct inaccurate personal data, to add to their data. There's also a right to data portability, so that you can take your personal data in a machine readable format and then transfer it maybe from one company to the next. And a question about this has come up a number of times. What if a customer wants you to delete all of their personal data, but you still are providing service to them? Maybe you have to still send invoices to them for payment for the services that you have. Is this an automatic, as soon as someone asks you to delete data, you have to reply and respond right away? I just want to clarify that the right to be forgotten is not an automatic, absolute right. There are some circumstances where you can accommodate that request without undue delay, but if it's still necessary for the purposes for which that data was originally collected, then you may still be able to process the data and retain it for those purposes. So it's really a case-by-case look at how to respond to a request to delete data. Well, this is an interesting one. Whether deadlines, we had just talked about, Eric had answered the question whether to update privacy policies and whether there's a deadline or a time frame to update policies, whether it's for the GDPR or compliance with any privacy framework. My general advice is that you should consider your privacy policy always a living document that you should revisit in changes in the type of data you collect, if you have a new vendor, if there's a new law that applies. And so updating a privacy policy is something that, especially upon material changes, you should revisit and continue to refine and update it regularly. But it's not that there's a particular deadline to do so.
Yeah, another question was, how does the EUUS Privacy Shield fit with the GDPR? Is it GDPR compliant? Well, in fact, many authorities think it is not entirely compliant with the GDPR. And that is why, for instance, the European Commission already raised a number of concerns, although they think indeed that it should still be okay. But now recently, on the 5th of July, also the European Parliament approved a resolution which sets out a deadline for the US to revise the Privacy Shield in order to make it compliant with the level of adequacy and protection required by the EU. So in practice, that means that if by September the 1st, the US would not reach the levels of adequacy demanded by the EU, that is the resolution that was adopted by the 5th of July, so last week. So there's still a big level of uncertainty about whether the Privacy Shield will still stand or whether new rules or new mechanisms will be necessary in order to make sure that transfers of personal data from the EU to the US will become lawful. I guess that we dealt with most of the questions that were raised by the audience. There is one also, how does the GDPR applies to IceP, as ISPs have no access to the information transmitted? Well, if that is indeed the case, if you don't have access to any personal data, then you're not a data processor, in my opinion. As soon as you process data, and processing of data can be really considered in a very broad way, but as soon as you process data with regards to services in the EU, or if you are established in the EU, then you will become subject to the GDPR in the EU as well. If you don't have any access to personal data, the answer might be that you would not process any kind of personal data.
We received a question, what is the panel's stance on dynamic IP addresses in the hands of a website operator? Is it personal data? The answer on that one is somewhat unclear, but one aspect to note is that GDPR does talk about individualized identification of a person, and so where there is a IP address that is even a dynamic one that is typically used for one person, there is concern that could identify the person. So what some, and this is still an emerging area, but what some companies are doing is omitting logs that have the final few digits of the IP address, so that you have some information, but not the individualized information. So whether that's the correct answer or not, that is what some are doing.
Yeah, Alex, I can maybe also add on that because this stems also from a decision which is made by the European Court of Justice some time ago, in a case where also one of the questions that was raised was whether from the perspective of an internet service provider, an IP address is personal data. Even when that would be some kind of dynamic IP address. And I think it was decided by the European Court that indeed, even a dynamic address can constitute personal data when a company has the legal means to obtain additional information held by another company, such as an IceP, to identify the individual.
So here's one final question. We're going a little bit over time, but it's asking whether we have any templates, whether we would recommend any template privacy policies. I've also been asked about templates, even though there are standard contract provisions for specific contractual obligations. We don't offer templates, and part of it is along the same lines that you really need to look at, especially in a privacy policy, whether it's related to the GDPR or otherwise. I always want to make sure that a company really does keep the promises that are in the privacy policy. And so it's really important not to just, and I would encourage any companies not to just sort of Google around, find a privacy policy they like, and then adopt it as their own. And the same goes for a lot of GDPR language that you might find, contractual provisions with vendors. Don't just adopt something that someone else has negotiated. Make sure that this fits with your practices, with your data security measures, and that it covers everything that you need to cover without promising more than the protection that you actually accord.
Thanks, Linda. And I think we're out of time. So thank you, everybody, for participating. We had a question, will there be a replay of this webinar? The answer is yes. We post our webinars after the event on our website. So please feel free to, once that's up, to review it. Also, the handout for the webinar is on the right-hand toolbar of your screen. So thank you again, everybody. Thanks, Linda and Eric, and have a great rest of your day. Okay, bye.
Thank you. Have a nice day.